Hi, my name's Jen Miles and welcome to this new for 2014 FAQ video on the subject of statutory demands. I am a member of the debt litigation team here at Cassell Moore, and I'm delighted to be with you here today to instantly cover at the click of a mouse some of the more common questions that our clients have about statutory demands. I hope that you find this free question and answer session useful, and I'd be happy to speak with you in person regarding any follow-up queries that you may have. There are contact details at the end of this video, and you can also connect with Cassell Moore through social media, including Twitter, details of which can be found in the description below. If you're in a situation where a person or a company owes you an undisputed sum of money, and that sum of money is equal to or in excess of £750, a commonly used method of obtaining payment is to serve the person or the company with a statutory demand. A statutory demand is a formal written request for the money owed, and although official involvement from a solicitor or from the courts is not strictly necessary, there could be important long-term implications over the exact wording of the document and over the manner in which the demand is served. In England and Wales, there is a strict time frame of 21 days associated with the procedure. Therefore, if you have been issued with a statutory demand, or if you intend on using a statutory demand, we would recommend taking expert legal advice as early as possible. When we speak of cases where a statutory demand is not strictly necessary, what we are really saying is that an individual situation may not necessarily require a demand to be served, because another route can be or already has been taken. However, if you are not in a situation whereby you have a pre-existing court case relating to the money owed to you, serving a statutory demand could be the first step towards securing the payment. If you are considering issuing a statutory demand, either against an individual or a company, we recommend taking early legal advice, as this could prove fundamental to the eventual success of your claim. The procedure for serving a statutory demand is well defined and can be complex. For example, when serving an individual with a demand, the document should be served directly upon the defendant. This could mean delivering the document in person, or could entail making use of a delivery service. Depending on your situation, we'll be able to advise you on the best strategy. In contrast, and because a registered company's makeup will normally consist of a board of directors, executives, managers, and even reception staff, the options for serving a statutory demand upon a company will alter. Again, we can advise you as to the best procedure in your case. The hope of the claimant is that once a statutory demand has been served, the person or the company will comply with the terms of the demand before further action becomes unavoidable. In England and Wales, the time limit within which an individual may attempt to set aside a statutory demand is 18 days. A failure to take action within this time frame will mean that the defendant is granted 3 more days in which they must either comply with the terms of the demand or face further action. Companies must secure an injunction in order to prevent the claimant from presenting a winding up petition, and equivalent timescales do apply. What is important to remember is that if your case does progress to court, any irregularity or contested grey area in the process up to that point could potentially serve to negatively affect the outcome of your case. We are here to ensure that, whether as the defendant or as the claimant, due process is followed throughout. The value of taking expert legal advice becomes all the more appreciable when we consider that circumstances surrounding your case could change in respect of any action taken by other relevant parties. This means that, given the inherent time constraints, you could require expert tactical advice in order to make certain that your response, in any eventuality, is beneficial to the swift and successful conclusion to proceedings. Under no circumstance should a debtor feel that in choosing to ignore a statutory demand, they are in some way demonstrating that the document is unworthy of a response and that it is therefore invalid. The validity of the document is never for the debtor to decide, and it is important to remember that a failure to respond to a statutory demand could lead to bankruptcy proceedings or to a winding up procedure. If you receive a statutory demand in England and Wales, you have a choice in how you wish to proceed. You may choose simply to comply with the terms of the demand. This would entail making suitable provisions for the debt to be cleared in a manner and in a time frame deemed satisfactory by the claimant. However, if you feel that you have significant grounds on which to challenge the demand, you have a strict interval in which to act before further action against you or your company may become unavoidable, meaning that time is of the essence. We are here to fully explain all of your options in plain English and offer expert guidance no matter what your situation. Taking early legal advice could be essential in ensuring that your case is successful. As we have seen in the answers I have given during this video, the topic of statutory demands is broad and there can be strict timeframes involved, which means that receiving timely expert advice could be crucial to the success of your case. Our experienced team here at Cassell Moore understands and appreciates the need for prompt, tailored solutions, because from the time that the demand is served, the clock starts ticking and each action going forward must be carefully considered. Therefore, if you are in a situation whereby you've been served with a statutory demand, or if you wish to serve a demand and you would like professional assistance to ensure the best possible outcome, please contact me, Jen Miles, on 0151 375 9940 or email us at debt@cassellmoore.com. Alternatively, you may wish to connect with us via social media, including Twitter. You can find details of this in the description below.